Hi, everyone. So, for this panel, we're going to be talking about some of the key issues in the legal landscape. Obviously, there's not much to talk about, so I'm sure it'll be a quiet, quick session. But clearly, the legal frontiers that AI has raised are fundamental to the world of publishing and the way that we do business and how we navigate the shoals and the opportunities that artificial intelligence will be bringing us together. So we're very, very pleased to have highly informed counsel in this session. So I'd like to introduce Scott Sholder. Scott, can you give us your affiliation, a little bit of a background, and if you want to make any disclaimers or notices, it's a good time to do that.
Sure. Thanks. Thanks for having me. My name is Scott Sholder. I'm a partner with the law firm Cowan Debates, Abrahams and Shepherd in New York City. Um, I'm headquartered in New York City. We have an office in New York and one in Beverly Hills. I am co-chair of the litigation practice here at the firm. And my practice focuses on copyright and trademark litigation, primarily in the entertainment and media space, and that includes art, publishing, music, um, theater, film and television, etc. Um, handle entertainment and media business disputes as well as intellectual property cases. That's really been the focus of my practice for the last I don't know decade or so. I was at a large firm for several years as an associate in their litigation group before I joined Cowan Debates, and clerked in the federal courts for 2 years before that in the New Jersey District Court and the Court of Appeals for the Third Circuit. So that's very quick sketch of my path to where I am and general overview of my practice. My standard disclaimers that the views that I'm expressing are mine and not those of my firm or my clients. And in terms of other disclosures, I'm sure we'll get into this, but I am currently one of the attorneys representing the plaintiffs in the Authors Guild litigation against the OpenAI companies. So just putting that out there because to some extent my comments will have to be a little bit more narrow than they would have been when I originally joined this panel. I did not have this case going on just yet. So that's my opening spiel.
We're very pleased to have you, and obviously you bring in both expertise and context, and we appreciate the guardrails that are legal and not AI that will work around. So,
Thanks.
let's try to address some of the many, many topics that AI raises in the legal landscape. When we were talking early on, we had a long, rambling discussion, as these discussions can tend to be. And you noted towards the end of it that in your mind, a lot of the issues, generically, if you will, tend to come down to 2 points: protectability and infringement. Could you define those two terms briefly for us and the legal understanding of those words, and just spend just a couple of minutes on each of those to lay out some of the issues?
Sure. I think it's easy. It's easier to kind of classify the legal questions into kind of these two buckets, right? There's the question of protectability, authorship, and ownership of AI generated material. Then there's the question of infringement in terms of whether the use of existing materials in the training of AI algorithms and various models is infringement or not, and whether the resulting output is possibly infringement. So, starting with the ownership and authorship issues, um, there's been a lot of discussion lately about um, to what extent can one own AI generated content. Um, the case law and the position of the Copyright Office on this issue has generally and pretty consistently been there has to be human authorship in order for a piece of content that's fixed in a tangible medium of expression to be deemed copyrightable and therefore protectable. Um, there are cases that have said works created by animals are not copyrightable, works created by celestial beings allegedly are not copyrightable, and the latest is discussions about to what extent can a machine own copyrights. Um, the question comes down to kind of how much input a human uh, provided to the piece of content. There are a couple of cases going on within the Copyright Office and some in litigation. You might have heard of Chris Castanova, who created a graphic novel that incorporated AI generated images with human authored text. And the author edited those images and compiled them to some degree as well. Um, and that went through the Copyright Office, and there were some written opinions and guidance on to what extent that material could be copyrighted. Um, Similarly, a computer scientist named Stephen Thaler had created a machine that itself generated a piece of art and has been litigating the Copyright Office's denial of a registration for that piece. And that's working its way through the courts now, is in the District Court of DC. So um, the position of the Copyright Office and so far the case law is that if a machine was kind of the master of the creation, then the creation is not going to be copyrightable and not registerable. Therefore, you can't enforce your rights in it. Um, it begs the question of when does it become protectable? And the Copyright Office has issued some guidance on this, has had some webinars, and has determined that if there is more than de minimis human input, then that human input can be deemed copyrightable to the extent that it's independently protectable in and of itself. But the AI contributions have to be disclosed on the registration form. So there's some technicalities that go into to what extent you can register hybrid human and AI work, but a fairly clear line that if there is no human contribution to the work, then it's not protectable.
This, and I should note, to be clear, and we'll get to this topic earlier, but Scott, is it a true statement that the Authors Guild action is focused primarily on the protectability issues of content?
No, it's more about the use of existing material pulled from online sources and used as training data for the large language models.
Okay, excellent. So on this issue of copyright determination, I know that this is a matter of active dispute, obviously, among many counsel. I think many legal scholars feel like the Copyright Office is frankly in a very difficult position here, trying to adjudicate what the impacts of a new creative technology are, and how they mesh with human creativity. So it's really quite the kernel of our understanding of copyright, and what is it that we're protecting. Issues around authoring here are very complicated. There's a little bit of prior art and prior struggle over these issues. Photography is the example that's most frequently used, where originally it might have been, or it was interpreted that the camera was a machine, and therefore the output of that machine was not copyrightable, was not capable of protection. But it has evolved to a point where the photographer is very much seen as a creative artist, controlling the determination of a product, utilizing machinery, utilizing an automated process, and therefore copyright extends its protections in almost all cases to that kind of output. There's similar structures in some analogous fashion, where you can imagine a creative animation artist at a major studio working with software from a company like Adobe or other types of software that generate images, anime, cartoons, and so forth. And obviously, those software are under the guidance of humans. So this is part of the nexus that the Copyright Office has to to navigate. Can you help us distinguish what's unique here about the landscape that AI is bringing to this table?
Sure. Yeah, that's a really great question, and it's something that people have been talking about a lot, and wondering about because it isn't really intuitive. That you're correct about photography. Certainly, for many years now, photographs have been deemed protected works of visual art under the Copyright Act. This case from a long time ago, involving a photograph of Oscar Wilde, where the Supreme Court held that the photographer's kind of arrangement of the lighting, the set dressing, the costumes, the props, arrangement of the camera, and setting of the scene was creative enough to deem them the author of the work, even though the camera is the machine that actually captured the image. I think the line starts to get a little bit blurrier as you move towards things like software that automate those processes a bit more. And now, kind of at the opposite end of the spectrum is generative AI, where I, there's no real creative control in terms of what comes out the other end. You can put the same prompt into different, visual art AI engines, Midjourney, Stable Diffusion, and you'll get something different. And it may not necessarily match what's in your head. Whereas the photographer can set up the shot and know what they want to see when it comes out in the dark room, or from or on their computer. And the graphic designer can manipulate things and know and have some creative control over what the end product is going to look like. Generative AI, in terms of creativity, it tends to be a bit of a black box. Like I said, the output doesn't necessarily match what's in my head. And there are ways to tweak that. You can, revise the prompt, and you can paint on top, and you can manipulate using other programs, and you can make it look like what you want it to look like, at least in theory. But I think, my understanding of kind of the difference, where the line is between these types of technologies, is that the user is not necessarily the creative mastermind. And if you look at the Copyright Office guidance from March of this year, that's kind of what it was getting at. This guidance came in the form of kind of a written memo after the Castronova decision, to provide more guideposts for the public about these issues. And when the human is not in control of the ultimate product, I think that's kind of where the line drawing happens. But it's not easy line drawing. Nothing about this is clear, really, in terms of what is enough to constitute copyrightable contributions to a work. According to one of the Copyright Office's webinars, the line is de minimis contribution versus contribution of something that is enough to be copyrightable in and of itself. The bar for originality on copyright is pretty low. So it kind of begs more questions than it answers, but it does provide some rough outlines for where the lines are drawn.
And I should note that the Copyright Office has recently published what's called a notice of inquiry, seeking comment from firms, individuals, organizations who are working with AI and interested in the various applicability of copyright to generative creative material. So there are a couple of deadlines associated with that. You can find what's abbreviated as an NOI on the web, and I know that many people will be submitting comments to the office this fall for that. For those of you without a legal background, de minimis just means that there's a minimal, literally, engagement. So the phrase is used in various contexts, but you can imagine that in a de minimis exercise of human creativity, it just means that there would be an extremely light human hand in that, and so forth.
I forget sometimes that terms of art are terms of art, and not necessarily translatable to normal human life.
Yes, we all have our own professional terminologies and ontologies. Um, so one of the difficulties with AI, I think, in the legal landscape is that it is invoked on both the harvesting side and then on the generative side. Uh, Either one of those could be quite complicated. AI, in some ways, is a unique challenge for posing both parts of that equation. So I'm wondering. Uh, if we can touch briefly on some of the harvesting issues. And to clarify, I think many of us are aware of this at this point, but the way a large language model works is it doesn't harvest bodies of textual content and then store them as that content. It's a very complex mathematical model in which it takes words or fragments of words that it calls tokens, and it maps out the probability of their co-instance, their relationship over a very large multidimensional space. So there are a lot of examples about how large language models can generate text given that given the inputs that they utilize to build their models. But it's certainly in most cases not a 1-to-1 ratio in terms of harvest to output. And so this is this is one of the challenges. Is many people have used this analogy of a grain of sand into the model, and ultimately the model can produce a sand sculpture on the beach, but keeping track of each grain of sand is particularly difficult. And so, Scott, can you help frame um, that issue for us?
Yeah, I mean, I think there is some information out there about where the kind of training material comes from, and there are some players in the space that are more opaque about it. Um, by and large, the training data that's used by a lot of the major players in generative AI comes from the internet. Um, whether it's caches of images or text or books, most of it not necessarily meant to be copied. A lot of this material is scraped without authorization, and copied and then used for training of the models. Again, it's not. There are ways of figuring out where some of this content comes from. So a good example is in the one of the first class actions that was filed, the Getty Images case that's pending in Delaware against I can't remember if it's Midjourney or Stable Diffusion or both. But one of the output images, as shown in the complaint, had a garbled Getty Images watermark. So that was very clear evidence that it came from Getty Images database of materials. Um, so that's not going to happen all the time, but there are ways of determining what's in there. If the model can spit out something that suggests that it knows the content that you're talking about, then it's likely that the inference is that it was used as training data. Um, Again, the process for the collection of the material is complicated and often opaque. But there have been public statements by some of these companies that they know that they're using material that's out there, whether it's free to use or not, and that copying has taken place. So there's tons of content on the internet, and you need tons of content in order to train a model to be effective and to do what you want it to do for it to be commercially viable. And so that's where those materials are going to come from, and most of the time it's not licensed. And there are some players that have, I guess, what you would refer to as clean data sets that have either been licensed or created in house. But these are not the kind of the major players that everybody knows about.
And clearly, in terms of the market for image generation, we're certainly seeing many of the existing commercial players that support visual media, such as Adobe and Getty Images, as another example, begin to work with enhanced models that explicitly permit the create or provide for the creation of material that they believe would be clear of infringement. So we're beginning to see firms in some creative spaces begin to adapt to this. Now, one of the concepts that's frequently bandied about is a concept called fair use. And many people would argue that the harvesting of openly available content on the web and this kind of algorithmically churning of that material in order to build the LLM engines is a characteristic of fair use. Fair use is a complex part of law and its interpretation. Briefly, that there are four factors that go into determining whether something is fair use. And just very quickly, those four factors are the purpose and character of that use. Often, this is interpreted as how transformative is a use. Another is the nature of the copyrighted work. So an example of this is this a fact-based nonfiction, or is this a fictional piece of work? There are many other types of divisions there. The amount and substantiality of a portion used to copy. In this case, if an entire work is harvested or indexed, that doesn't necessarily rule out fair use, but it is one of the factors considered. And then finally, the effect of the use on the potential market or value of the copyrighted work. And it's some of that area that we've seen recently invoked in the Warhol case that appeared before the Supreme Court. And Scott, can you talk briefly about some of the conceptual issues about commercial impact for AI tools in the marketplace, and to what extent how would you sketch out some of the crossing lines that might exist in the generative AI space?
It's a little bit hard for me to go into much detail on this because this is going to be a significant issue in many, if not all, of the cases that are pending, including my own. Fair use is a very, very gray area. People have strong opinions on both sides. My clients have taken a stance. There will be strong opposing viewpoints to that position, I'm sure, and a court will have to decide on those issues. To your point about the factors, I can say kind of more generally that the key questions are going to the key question in any fair use case is really the first and the fourth factor. Historically, the second and third factors have not been determinative, and almost every case going into an in-depth fair use analysis says, yeah, we'll consider the second and third factors, but they're not necessarily dispositive of the whole question. So
just to reiterate, those are the transformative interpretation and the commercial impact interpretation.
So the first factor, the purpose and character of the use, has kind of two subparts to it. Is it commercial or not, and is it transformative or not? That plus the fourth factor, the impact on the market and potential market for the infringed works, are usually get the most attention and the most weight. The second factor, the nature of the work that was infringed, what is it? Is it more factual or is it more creative? And the third factor, the amount and substantiality, are typically not determinative. That doesn't mean that they won't be in some future case. But the first and the fourth factor tend to carry the most weight. In the Supreme Court, at least in the Warhol case, focused more on the commercial nature of the use, as opposed to really getting into the nuts and bolts about what constitutes transformative use. But yeah, the question is going to be, is what the generative AI companies are doing, does that constitute transformative use, and does it constitute a commercial use? and how does that factor in with the fourth factor? Because they're kind of related and they kind of play off of each other a bit. Um, to what extent does it impact the market for the works, for uses of the works that are at issue? So those are going to be the key issues, and I, can't say how a court would come out. And getting parsing the case law is not something I can really do, but it's all of these. I think all of these cases, the extent that defense is asserted, are potentially going to turn on that. There are some threshold issues that have come up in other cases, like having a copyright registration, or pleading with specificity, not necessarily specificity, but adequate pleading about works being used. Those have come up in prior cases, but by and large, I think this will, fair use will be a very important part of this dispute, or all of these disputes.
And I think it's quite fair to say that fair use is a very live part of the legal landscape. It's constantly being revisited, and these kinds of technological horizons are really driving a lot of the journal conversation about how the courts interpret fair use and provide guidance for creative and cultural industries, as well as more commercial uses. So we're getting close to the end of the time that we have. And I think many in our audience would appreciate your thoughts on, how would you, I hate to use the word advise here because of some of the engagements that you're currently involved with, but what should publishers and authors consider as they think about navigating this landscape where AI generated works or guided works might be increasingly prevalent? And clearly, this again falls on both sides of this harvesting as well as creation side of AI. So, could you just give a couple of thoughts on that?
Yeah, the answer is going to be different, from looking at it from the author's side versus the publisher side. Just in terms of kind of the creation of the works, there are some authors that may want to use generative AI platforms as for ideation or for initial drafts. They're going to have to have an understanding with their publishers about whether and to what extent they can do that. Some publishers may not want them to, given the potential legal risks. And on the other hand, some authors might not want publishers to use any generative AI for things like editing or reformulating of paragraphs, or even for cover art. People are kind of drawing lines in the sand on their position on use of AI when it comes to various types of creative work. So those issues can be hammered out in contract negotiations. It's really going to depend on what position the publisher is taking with respect to the risks that they want to take if authors are using AI generated content. Again, it's going to be a hard exercise in line drawing if certain publishers are okay with authors using AI. Uh, to my point about protectability, there has to be sufficient human input in order to have a protectable copyright. So that impacts both authors and publishers, because the author needs to be able to enforce the copyright, and the publisher wants to make sure it has kind of a clean chain of title to be able to do what it does with respect to distribution and audiobooks and things like that. So there are a lot of potential potholes, and I think it really will come down to the contracts and negotiations between the authors and the publishers, and how they feel about particular issues, and how AI kind of weaves into their practice.
And we're at the end of our panel. I just want to give you 30 seconds or a minute, hopefully, to give a brief impression. AI is not confined to the shores of the United States. This is a global issue, and our understanding of copyright is being shaped globally. In this area, as in so many others, the European Union seems to be taking a more aggressive stance. Do you think that EU regulation and law will end up helping to determine or shape the American context, or do you think for now it's evolving quite distinctly?
My gut reaction, without a ton of study on this, is to say that it's evolving distinctly. I mean, if you look at our United States participation in the Berne Convention, we kind of adopted it, but not really. We still are, I think we're the only country in the world that requires a registration in order to sue. Maybe not the only one, but certainly one of the few. And so, given our reticence to buy into things like complete lack of formalities, moral rights, things like that. The American copyright system is and always has been quite distinct. So it wouldn't surprise me if the two proceeded on parallel tracks. Whether they'll intersect somewhere in the future, I don't know.
Right. All right. Thank you so much, Scott, for your time today. We really appreciate it. As Marcus Stola said in the opening remarks, copyright is key for this industry, and being able to reward authors for their contributions and for publishers to safeguard their intellectual property is certainly key to the industry. Thank you for your insights, and I'm sure that the number of questions will only grow as the months come by. Thank you
That's
again.
great. Great. Thanks for having me.